now. Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Trinity presenting for us. If you are unfamiliar with the format of this event, first, Trinity is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session, excuse me, at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Trinity will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Trinity to get us started.
Hi, everyone. Thank you for joining us. Like Marissa mentioned, my name is Trinity Ojeda. I'm an attorney with Legal Aid out of the Raleigh office. I primarily do domestic violence work, but I also handle custody-related matters kind of as it relates to domestic violence. But we'll kind of go through this presentation. We are able to kind of tell you the general process of things, but obviously no advice of like facts, law to facts kind of things. But Marissa is going to keep an eye on that, and we can kind of just go through this presentation. So this is a presentation based on child custody matters in North Carolina. And okay. A little bit about Legal Aid. We are a statewide nonprofit law firm that provides free legal services in civil matters to low-income people in order to ensure equal access to justice and to remove legal barriers to economic opportunity. We have a range of areas of practice, including housing, employment, education, domestic violence, disaster relief, and consumer. And we have monthly listen and learns for simple divorce, child custody, criminal record expunction, tenant rights, Social Security disability, Medicaid rights, SNAP 101, emergency SNAP, Medicaid eligibility, and healthcare power of attorney and living wills. And registration information is below. And so a little bit about this listen and learn. We do not represent you, like Marissa was saying. The intent here is just to help y'all represent yourselves. So pro se representation. Pro se just means that a party to a case is representing themselves. And it is about representation for the initial filing of custody and or visitation, but it applies to North Carolina law only. So this listen and learn provides assistance initiating a custody action if you already have a custody case pending or a custody order in place, not including temporary custody pursuant to a domestic violence protective order. You need to file a motion to modify, not attempt to initiate a new case. So information about motions to modify are available upon request. So a little bit about the law, North Carolina General Statute, Section 50, and Section 50A speaks to child custody more specifically. Section 50-13.1 speaks to child custody and mediation. Legal standard for parents is best interests of the child. So that means that the ultimate goal of a hearing is to determine what the best interests of the child are, or what the best kind of situation or custody arrangement is in the best interests of the child. And then the legal standard for non-parents is unfit parents. So if non-parents are attempting to obtain custody over a child and the parents are on the other side, they have to show that the parents are unfit rather than it being a best interest determination. Although those are kind of similar. And I mean, if there's a suggestion that unfit parent or that parents are unfit, then there's kind of also the suggestion that it's in the best interest of the child to not be with them. Um, so terminology and definitions: plaintiff, that is the person initiating the case. Defendant, that is the party against whom the case is filed. For the purposes of custody, there's no real distinction between, uh, there is a distinction, but there's not necessarily any relevance based on who files against who. Ultimately, the important thing is determining the best interest of the child. Pro se, like I had mentioned, that is when a party represents themselves. So if you initiate an action, or if an action is initiated against you, then that means, and you're representing yourself in those actions, that means you are pro se. Primary custody, that is, well, primary custody means that you will likely have primary physical custody, so meaning that the child is with you, or with the party who has primary custody the majority of the time. Visitation is essentially like secondary custody. That is all the time that the child spends with the parent who doesn't have primary custody. So that could look like things like every other weekend. That would technically be like a visitation schedule. Um, if it's split down the middle, that would just be 50-50, and it wouldn't necessarily be primary. Legal custody is the ability to make important decisions that affect the child. So these are things like doctors, which school they'll go to, religious practices, those sorts of things deal with legal custody. Um, Legal custody can be joint. It can also be one person having legal custody, sole legal custody. If it's joint, it means the parents have to work together to come to a decision. If it's one person has sole legal custody, that means that they make the important decisions. Also a note, just because someone has sole legal custody doesn't mean that they don't have to inform the other parent. It just means that they get to make that decision. So it's going to be subject to whatever the judge kind of, or however the judge limits that. Physical custody, like I was saying before, as it relates to primary custody, that is where is the child physically located. And generally, there is kind of the day-to-day decision-making power when the child is in a party's physical custody. So about the law, who can sue? A parent, a relative, a person, agency, organization, institution that claims a right to custody. So someone with a relationship to or with the child. Where to file? The best place to file is in district court in the county where you reside, or the county where the child and other party reside. That'll kind of just depend. Um, when to file, generally at any time after separation. However, the child must have been a resident in North Carolina for at least 6 months prior to filing for the court to have jurisdiction. If the child is younger than 6 months, the child must have lived in North Carolina for the majority of his or her life. So the 6 months is dealing with uh, jurisdiction under kind of an interstate compact, but the primarily the county is going to deal with like the venue of the court. So you want to choose the court that is most convenient for the case. So where you're living at the time, if the child is there, you don't want to overthink it. If it's not the right place, that's okay. There's ways to correct it. So parental rights. Until a written order exists, both parents have equal rights to a child. Law enforcement will not help you retrieve your child from the other parent unless there is a court order in place specifying them to do so. If your parental rights have been terminated, you do not have a right to sue. So you do not have a right to sue for that custody. Child support and child custody can be litigated separately. They do not need to be litigated together. So it's important to take into consideration what you're seeking when you file. So when you go to file your case, what are you looking for? If it's joint custody, it means that both parents will share custody, both parents will make major decisions, and usually the child will primarily reside with one parent. If it is exclusive custody, that means that one parent has custody. One parent makes the major decisions, and the child lives with one parent, but other parents usually have some sort of contact or visitation. Visitation is the non-custodial parent's time to see the child and their right to exercise that visitation. The amount and the type is determined based on the um, age of the child and how close the parents live to each other. There is usually a very regular schedule. You can certainly look up various kind of arrangements of schedules if you are curious about the different kinds. So before you file, do you need to file? Uh, it's not needed to get child support. It's not needed to get welfare assistance, to deal with school enrollment, medical insurance, or temporary child care. Um, and the drawbacks to filing are that a legal case is time consuming. There are likely going to be numerous trips to court. The court examines your personal life, meaning your employment, your mental health, your criminal record, your character, um, the significant other that you are with. Um, Lots of different things are what they were going to look at to determine the best interest of the child. Disinterested parents get involved suddenly, and the court may make disagreeable orders. So there are complications, and there can be complications. So, you know, take that into consideration before you decide whether or not it's the time to file. It's important to do a self-evaluation. Are you in a good place with your employment? Are there pending and past criminal charges that you're dealing with, that you're still dealing with, or that have kind of subsided and are in the past fully now? What's going on with the driving situation? Do you have the driver's license? Um, are you able to arrange transportation? Do you have that kind of under control? What's your living situation like? Where are you living? Do you have roommates? Are there other people who share your residence with you or that you share a common space with? Um, are you in a mentally stable place? Are you taking care of yourself? The court is going to want to know these types of things because they're going to want to make sure that when they place the child into a custody situation, that they're going to make the best decision they can based on the best interests of the child. So are there also prior court orders? And this doesn't necessarily mean just um, custody orders. You know, are there previous domestic violence cases or orders? And it's not that that should require that you not file, but it's important to at least take into consideration of how might this affect the case. Um, and then custody versus visitation. Are you in a place where you want primary custody, where you want your child to be living with you the majority of the time? Or is visitation an acceptable alternative that you're open to? Just important things to look into and to take into consideration when you're determining whether or not this is the right time. Do you need a lawyer? So ask yourself these following questions. Will the other parent be cooperative or will they fight for custody? Is the other parent likely to get a lawyer? If the other party gets a lawyer, will you be able to get one? So you should get a lawyer if your custody case is contested and the other side has an attorney, or after reading the entire packet, you feel you need help filing for custody. There are plenty of cases that go in front of or go in custody court that are two parties trying to figure things out. And there is a mandatory mediation aspect. So it's also okay not to necessarily have the answer to this question right away. So the roadmap. You'll need to complete the forms, file the forms, serve the defendant, and then next will be mediation and then court. So ready to file for custody. Paperwork, paperwork, paperwork. Those 6 documents, the civil summons, the complaint for custody / visitation, the domestic civil action cover sheet, the Service Members Civil Relief Act declaration, the affidavit as to status of minor child, and then optional, the petition to proceed as indigent. These 6 forms are going to need to be filed together. Um, 5 of the 6 forms all have like a administrative office of the courts form. So these are forms that you can access through the internet. They should be in the packet. And even if they're not, if you need like a second one, or if you just want a reference, you can Google that and you would be able to find those. Um, the civil summons is just requiring the other party, it's kind of the formal way to start the case, requiring them to um, understand that a case has been initiated against them in a specific court. The complaint is essentially laying out the required elements to be uh, complained of, essentially, to let the court know that you are seeking custody. Domestic civil action cover sheet, that is to inform the court what the complaint, essentially what you're filing and what action you're instituting. Service Member Civil Relief Act declaration is essentially allowing the court to understand whether or not the other party is in the military, because that could change a little bit about how the court goes about the case, especially if the service member gets deployed or gets orders. Affidavit as to status of a minor child is essentially just you providing an affidavit to explain where the child has been living for the past 6 months, all the way back as far back as 5 years, I believe. And then optional, the petition to proceed as an indigent. This is if you may not be able to afford the filing fees, because there are filing fees once you file, then that may be an important option. So you can complete the forms typed or by hand, and you can do so in black or blue ink if it is by hand. You should have the original completed plus 2 copies of each form. Some counties may require additional forms, and that website, the nccourts.gov website, has a location to access all these forms. You can also just kind of, I mean, you can type in NCAOC and then type in these form numbers or even these form names, but you'll get there. Um, and it's important to check with the county that you're filing in just to make sure that you have all the forms. And while clerks will not give you legal advice, they usually will be open to letting you know if a form is missing or something like that, but they cannot tell you how to fill it out necessarily. So accessing the forms online, this is what the North Carolina courts or nccourts.gov looks like. This is the administrative office of the courts website. You can click on forms. If you see in the top banner, I don't know if you can see my cursor, um, but the forms are located there. And then it'll take you to a spot that looks like this. And you can type in the keywords, or you can search by form number. And then there is also a section for looking for forms by county, or you can search every county's local forms all at once. And then the petition to proceed as an indigent. So that is Form AOC G106. If you cannot afford the filing fee, you use this form to request a waiver. So do you receive food stamps, TANF, or SSI, or are you represented by legal services? If not, discretion of the clerk applies. Be prepared to move your case to the clerk, or sorry, to prove your case to the clerk. So proving why you will need this ability to proceed as an indigent. It is very important on all of these forms that you do not lie. Your statement should be, to the best of your knowledge, factually correct. And if you are unsure, that is a good opportunity to double check. And then again, to the best of your knowledge. So you could be held in contempt of court for giving false information on this form. This form must be signed and dated in front of a notary. And this is what that form looks like. I know it's a lot, and at least from my perspective, when I have first started looking at all these forms, there's a lot to go through. It is important to read through everything just to make sure you're not missing anything. And it is important to complete it to the best of your ability. So correct to the best of your knowledge and complete to the best of your ability. Let's see. Then there is the civil summons. This form, AOC-CB-100, is used to serve the defendant. Under State of North Carolina, you will write your county name, where you plan to file. You'll check the box for district court in the upper right corner. Write your name and address as plaintiff. I feel like this would be easier if I could reference the other. Here, let's see. Okay, so under State of North Carolina, you will want to put the county, then you'll want to put the file number, you'll want to note that it's district court, you'll want to put your name, your address, your city, state, and zip. And then under that, you will put the defendant's name. And then I believe you also put their address. So where do you want them to be served? So this is where you know them to be located. And then you'll want to you don't need to put anything in the box at the bottom left saying name and address of plaintiff's attorney. You would actually just put your address there as you are representing yourself in the matter and filing this. Remember, you'll want an original plus 3 copies. You'll need 2 on yellow paper and 2 on white. If there is no yellow paper, then you should write for service on 1 copy. The yellow copy is for the defendant. The original is for the clerk. The white copy is for you. You may need an extra yellow copy for return of service from the sheriff if serving by sheriff. And then the complaint, there's a sample located in the pro se packet. The one in the pro se packet is designed to be self-explanatory. There should be no blank spaces unless you are sure that it does not apply to you. On the verification page at the end, it must be notarized. You should have an original plus 2 copies. You should fill in the county, your name as plaintiff, and defendant or defendant's name or names. So let's see. So in the first paragraph, you'll fill in the county where you live. In the second paragraph, you'll fill in the county where the defendant lives. In the third paragraph, you'll check the box which explains your relationship to the defendant. In the fourth paragraph, you will fill out the full names of the children involved in the case, including their current age and date of birth. Then in paragraph 5, and then additionally for each child, you will fill out where the child has lived for the last 5 years, including address, name of individuals child has lived with, and current address of the child. Check the boxes, if applicable, concerning other litigation or lawsuits concerning custody of the minor child, and check boxes if other individuals have custody or claims custody and or visitation. In the 6th paragraph, and there's space in there to add additional children. So if you need to add more than what's available, you can. Just be mindful that you'll need to make sure that you're adding those spaces. So number 6, select the applicable box for custody or visitation. Number 7, you'll leave as is. Number 8, you will select the appropriate box to show grounds for proper jurisdiction, prayer for relief, wherefore, and you'll select the box that is applicable for custody or visitation. You do not date and sign the document until you are before a notary. So once all the information has been added, you just wait until you can get in front of the notary before you take care of that section. The notary, or when in the presence of a notary, you will date and sign the complaint and include your printed name, phone number, and address. The notary will fill out the information for the verification section. So this is what that looks like. And that is the verification page. So then you'll have the affidavit as to status of minor child. This is Form AOC-CV-609. You'll fill out one form for each child involved in the court case. The form must be notarized, and it is essentially looking to where and with whom the child has lived over the past 5 years. This is what that form looks like. And then the domestic civil action cover sheet. So that is Form AOC-CV or AOC-CV-750. Like the civil summons, you'll write the county name under state of North Carolina. You'll write the file number in the top right. You should write your name and address under plaintiff. Write the name of the defendant in checkbox yes next to summons submitted, which is directly located underneath, or sorry, located directly underneath name of defendant one. Then you'll also want to mark the initial filing in the top right under domestic civil action cover sheet. You should also select no next to jury demanded in pleading. In the box that states name and address of plaintiff's attorney, if there is none, you would just put your name, address, phone number, and email address. Under type of pleading, you would select complaint, and under claims for relief, you would select custody and or visitation, depending on what you're pursuing, and then you would sign and date the form at the bottom. With this form, you should have the original plus 2 photocopies. The original is for the clerk, 1 copy will be for you, and 1 copy is for the defendant. So on the left at the bottom, you can see where it says type of pleading. That's where you would mark complaint. On the right, under claims for relief, that is also where you would mark custody. So the custody mediation cover sheet, these cover sheets are county specific. So ensure that you have the one that is proper for your county. The form is used by the mediation office to schedule orientation and mediation session dates. You should fill in all relevant information, which may include items such as your name, address, date of birth, phone, and email for the plaintiff or the party initiating the case, as well as the defendant's information, so the defendant's name, address, date of birth, phone number, and email. Whether the parties were ever married, date of marriage, and date of separation, and the name, age, and date of birth of who resides with the child and their relationship to you. And then you should sign and date the form. So this is an example of that cover sheet for custody mediation. And that's sort of self-explanatory. Note that this one is for Robeson County. And then the Service Members Civil Relief Act, also shortened to SCRA. The SCRA is a federal law which protects service members' legal rights during active duty. It applies to members of the Army, Navy, Air Force, Marine Corps, and National Guard on active duty. The North Carolina Administrative Office of the Courts developed a form, which is AOC-G-250, which can be used to comply with the SCRA and requires a search of a federal website to determine whether an opposing party is an active service member. The form can be found at that link. And the link below that can be used to determine whether the defendant is in federal military service. That link is also available, well, I think I'll save that actually. So if a service member is on active duty, the court may not enter any order until the court appoints an attorney to represent the service member. If a party is on active duty, in most instances, the case will be stayed or postponed until a later date. This protection ensures that orders are not entered against service members who cannot appear due to their military duties. If you are filing a new lawsuit in North Carolina, make sure to always complete and file an SCRA affidavit when you institute your action. We regularly see actions for divorce that are denied by the court. because an SCRA affidavit was not filed. It is a very simple process that can definitely create an issue for your case moving forward smoothly. So it's just really important that you take care of this and you do so properly. Yes. On this form, you can see, I think, under the declaration itself, under paragraph 3, that the web link that was in the slide before the last one was also here. So you don't need to worry about keeping track of it there. If you locate this form online, and again, it's the Service Members Civil Relief Act Declaration, then you will be able to locate the link at which you can search the defendant's involvement or whether they're involved with the federal military. So filing. So you will take the original 2 copies of each document to the clerk. The original is for the court, 1 copy for the defendant, and 1 copy for you. You will pay the filing fee, or you will have the petition to sue as indigent approved, in which case you will not pay a filing fee. You will ask that copies of the summons be issued by the clerk and then have the sheriff's fee ready. There is a small fee for service by sheriff. And then the clerk will file stamped copies of summons and complaint, or the summons/complaint in marked papers with a file number. You should pay attention to the file number as it will be used to identify your case. So once you get these taken care of, you'll want to kind of split the copies up into their separate purposes. So like I was saying, the original goes to the court, and then you'll essentially have 2 packets of the same forms. One packet is going to be for you and for your records, and one packet is going to be for service in the method that you choose. And then how to pay. Remember, the clerk's office will not accept personal checks. If you pay fees, you must use cash or money orders. Another note, clerks are not lawyers, so they cannot give you legal advice. They may be able to help you with forms, but just keep in mind that they cannot tell you they cannot advise you about what you should put on the form. So just be mindful. They're not trying to be mean, they're just doing their jobs. So then service on the defendant, there are several ways to serve the defendant. One is by sheriff, meaning that you will follow the civil process for getting those documents to the sheriff, and then from the sheriff to the defendant for service. There is a fee for service of documents by sheriff. You can also send it certified mail, which again, be mindful that there is a small fee with that, or I guess an additional charge for sending something certified. And then you can also do publication by service by publication, which involves reasonable attempts to serve the defendant. And then after reasonable attempts have been made, you can publish an article in the newspaper in order to effect service, and it has to remain there for, I believe, like several weeks. That is usually the longest version of service. You cannot serve the defendant yourself, and your case cannot be heard without service. It is a requirement that the defendant be served. So service by sheriff, cost is $30 per defendant. It can be cash or money order to the sheriff's department in the county where the defendant lives. You give a file stamped copy of the complaint, essentially one of those packets, and the summons to the sheriff, and then the sheriff will notify the court when service is effective. They will update the court once they have completed service in the case. So service by certified mail, if the sheriff is unable to serve a defendant, you take a copy of the summons and complaint to the post office, and you can send the documents to the defendant's home address via certified mail. And you should request a return receipt in order to know that your essentially that the packet was delivered. You'll fill out a certified mail slip and a green return receipt card. When the green card comes back to you in the mail, you fill out an affidavit of service by certified mail. You attach the green card and sign the affidavit in front of a notary. You will make a copy for yourself and you'll give the original to the clerk. That is just so the court knows that you've gone through the process and you've received confirmation that those documents were served on the defendant. And if you have any trouble with dealing with certified mail, the postal workers are usually more than happy to be able to kind of tell you what forms or specifically what the certified mail slip and the green return receipt card look like, as well as what information may be needed to complete them. So this is an example of the affidavit of return of service by certified mail. You would just complete the information there, entering the county name, the case number, as well as the plaintiff name and defendant name. And then you would put your name on this where it says I, and then after that blank after that, and then you would essentially just ensure that you've done what this says before you sign off on it. And then you'll need to put the defendant's address where you sent it to, as well as the date that you saw based on the return receipt that the defendant was served. So what to expect next? After being served, the defendant has 30 days to answer. A defendant may do nothing, or the defendant may make a motion for an extension of time, or answer with or without counterclaims. If there are counterclaims other than custody or visitation, you should consult a lawyer. The case is automatically set for mediation, kind of like a North Carolina a law that custodies have mandatory mediation. Custody cases have mandatory mediation. So the court will provide instructions for you and the defendant as to that mediation. So the definition of mediation. So it's a process in which a professionally trained third neutral party helps parties develop an agreement for the care of their child or children during and after separation. The goal here is to give parties an informal forum to discuss parenting issues prior to trial. The way that it works is that there's an orientation session followed by informal, confidential meetings or just one meeting with a mediator. And the only documentation that leaves the meeting is a parenting agreement if one is reached through the process. It's important to definitely make use of this and just give it a shot. But if things are not working, I mean, they're just not working. This sort of mediation also is done without attorneys. So even if the defendant has an attorney, people going into this, it is just the parties without attorneys. Now, they could have talked to their attorney beforehand. So you should also just think about, you should have an idea of what you're looking for out of the case and kind of what things you're willing to compromise on and just kind of take those all into consideration before you go into mediation. Mediation should not be the first place that you're thinking about these sorts of things. You should have an idea of what you're looking for ahead of time. So standard visitation schedule, every other weekend with alternating major holidays. So things like Easter, Memorial Day, Mother's Day, 4th of July, Thanksgiving, Christmas, spring break, if the child is in school, and 4 to 6 weeks in the summer. The mediator suggests what to consider in making the parenting agreement, but it is on the parties to advocate for their positions. If mediation fails, all is not lost. You'd ask the clerk who is in charge of setting hearings to give you a hearing date and follow directions from the clerk. You would file a notice of hearing and a civil calendar request. You would serve the defendant with filed copies of both forms. You would also keep track of all the dates, all the court dates. It's very important to be on time because it reflects well in front of the judge, but also it just preserves your case. There is obviously room for emergencies, but they should be used extremely sparingly. So just be ready, be at court at the time that's required. If you cannot, if there's an emergency, that is also okay, but do remember that that should only be done very sparingly, and it should be an actual emergency. And then after you're aware of when the court date is, you should be gathering your witnesses who can testify as to your ability to care for your child and evidence that supports your claim that you're providing the best home for the child prior to the hearing. And again, here, your preparation is going to depend on what you're looking for. So in this, it talks about, that you are providing the best home for the child prior to the hearing. It's going to depend on, is this is your child coming to your home every other weekend? And are you ensuring that your home is appropriately prepared for that visit? It could look different for somebody who's looking to have their child with them all the time. So preparation will be different. Witnesses, the people that you're going to want to talk to are different. Um, and each case is kind of its own. So you'll just need to assess what you want to show the court to kind of determine what kind of preparation you'll need to do. So this is an example of a calendar request and a notice of hearing. You would fill out all the time in there. More likely than not, the um, clerk can kind of tell you some of the information here. Like they're the people who are going to be setting um, the time of the hearing as well as the courtroom. You can ask for a difference in those. Or a change, but generally they're the people who are going to have that information. So you'd need to talk to them about, what that should look like on this form. You will fill out the appropriate boxes, and then you will file that form and serve the defendant. So before the hearing, if you want to stop your claim for custody, you can file a notice of voluntary dismissal. A voluntary dismissal stops the entire trial, and that is unless the defendant has counterclaimed for the same thing, in which case it would only dismiss your case, but ultimately, even if they did counterclaim and didn't dismiss theirs, it would just mean that you would have a hearing that you had originally planned for. If this is solely based on your filing and they did not counterclaim for custody, then if you dismiss, the entire case is done. You can pick the case up to a year later when you dismiss, and you should dismiss without prejudice. Well, if you dismiss with prejudice, I, I don't actually think you can do that with custody because it's an ongoing consideration. Um, so just be mindful. If you dismiss the case, it could put a long pause in any headway that's being made. So again, carefully consider whether you want to start your case. And you should also take into account that it can be kind of a long process, and so you should be ready to stick with it. But of course, you do have the option to stop the case by voluntarily dismissing. But keep in mind, if they also filed for custody and counterclaimed it, just because you dismiss yours does not mean that theirs will be dismissed. This is an action of last resort. So again, be very careful about whether you want to do this, whether you want to initiate it, and then once it's initiated, whether you want to voluntarily dismiss the case. Preparing for trial. You should dress conservatively in professional attire. You should be on time, and you should absolutely not do any sort of drugs or alcohol beforehand or during trial. Um, I know that it's easy to feel overwhelmed in the situation, so it's important to check in with yourself, and it's important to be taking care of yourself through this process. Um, it's absolutely not a good idea to be doing anything that can reflect negatively on you in the courtroom, um, because the judge is taking that sort of stuff into account, even just while you're sitting there. Um, you should always tell the truth, and you should try to maintain your temperature and, or sorry, your temper and composure. So cool, calm, and collected. When testifying, you should stay calm. You should speak clearly. You should make eye contact with the judge. Um, and there are no juries in domestic cases. It's also important to remember judges are people, and it's okay if you get overwhelmed, or you're feeling a lot of different feelings while you're testifying. It's okay to take a second. It's okay to let them out. But the important thing is that you do have a time limit, and so collect yourself and try and move forward. Um, so it's okay to feel feelings. It's okay to feel overwhelming emotions. Try to control it if it's anger. Um, and try to collect yourself as soon as you can and then move forward. Um, and then after the hearing, the judge will make a decision verbally in court, and then write out a decision and mail it to you, or write out a decision and mail it to you. The judge's decision is called an order. You must comply with the order as it is written, regardless of your feelings about it. If you violate the order, the court can punish you for failure to follow the order. It is very important that you follow exactly what your order says to the best of your ability. Um, if you have questions about the order, you should talk to an attorney, um, unless the judge clarified about whatever your question was. Modification of orders, temporary orders require the standard of best interest of the child. A permanent order requires a substantial change in circumstances. Essentially, what this means is once an order has been entered, if the order is a temporary child custody order, then that order can be modified based on the best interest of the child. So it's essentially like once the court decides temporary custody, and then maybe in 3 months, it's not quite working, but it's close. So you just need to modify it a little bit. You can use the same standard that you used at the original hearing. So what are the best interests of the minor child, or what is in the best interest of the minor child? And then if you are able to prove your case, then the order is modified. But if there in situations like where it's a permanent order, um, that requires a substantial change in circumstances of the minor child, or substantial change in circumstances affecting the minor child. So just because uh, the just because it's not quite working, the temporary, or rather the permanent custody order isn't necessarily working as much as you had hoped, you have to prove that there has been a substantial change in circumstances that affect the minor child in order to change that order. Um, so yes, just be mindful. It's easier to change a temporary order than it is to change a permanent order for custody. So COVID-19 in court. Um, so courts have expanded operations. Uh, Operations may still remain below the normal pre-pandemic levels due to various circumstances. This is going to be county by county. The hours of operation of the clerk's offices within the state may vary from county to county. You should check with the clerk of court in your county to determine when the clerk's office is open for filing claims. Um, some hearings and mediations are being conducted remotely online. This is very county specific, so you should check with your local county clerk of court. An example of this is that I believe in Wake County, they do online mediation orientation. And it could depend county by county. There may be some counties that do in-person orientation. Um, so just be mindful. Best resource to determine the practices in the county in which you're filing is going to be that clerk's office or that courthouse. Um, there are some courtrooms, courthouses where face coverings and masks are still required. So again, be sure to check with your county. You should not enter the courthouse if you have traveled internationally within the preceding 14 days, are experiencing fever, cough, or shortness of breath, have been directed to quarantine, isolate, or self-monitor, have a known exposure to COVID-19, have been diagnosed with COVID-19, or reside with or have been in close contact with any person in the above mentioned categories. Use your best efforts to maintain social distancing, and you should monitor court updates and closures at the North Carolina Judicial Branch's Facebook page, as well as the North Carolina Judicial Branch's website. We are, a ways out from kind of the pandemic and everything. So some of these may be changing, but some are still in effect. The best way to know is just to check with your local court. All right. So Legal Aid of North Carolina's helpline is reachable at that number, which is 866 219 5262. We are also reachable at legalaidnc.org. And if you are looking for an attorney, you could use the North Carolina Bar Association's lawyer referral service, which can be reached at 919 677 8574. You can also go to their website or go to the link here, and you can get access to that. It provides you with a 30-minute consultation based on the type of case that you have for a fee of $50. All right. I think that's it.
Okay.
Marissa, do we have any questions?
Yes, we do have a couple questions. Just want to remind everyone that you cannot unmute in this forum. I do see some hands raised. If you have a question, you have to type it either in the Q&A box on Zoom or the comment section on Facebook. We cannot unmute you in this forum. So for those of you who have your hands raised, please ask your question in the chat. Okay. Uh, First question, I think this person is asking, the requirements for filing or the whole filing process, does that still apply when the other party is out of state?
Yes. And I think if I understand the question right, so requirements for filing and the filing process is still required when the other person is out of state. It does change how service is likely going to be affected. So sheriff or service by sheriff is usually going to be if the party's in the state. You can attempt to do it even if the party's not in the state, but likely what they're going to have you do instead is to reach out to the sheriff in the county in which the defendant resides in the other state. So you just need to contact their local sheriff's office in order to provide them with a copy to be served on the defendant. Ultimately, though, it's probably going to be easier to try it by certified mail if they're out of state. And yes, I think that kind of covers it.
Perfect. Does the clerk of court assign the file number?
Yes, my understanding is that the clerk of court is the one who handles that. Also, depending on the county that you're in, some counties have designated family court offices. So you may go to the main clerk of court and then you may just file everything there, but then they may send you over to the family office and that's where you'll actually be assigned to a judge or assigned a case number. But yes, the clerk of court handles the case number.
In mediation, is it just the two parents, or can, let's say, one parent bring like their parent or something? Or is it just between the two parents of the children at issue?
So my understanding of the mediation process, the mandatory mediation, is that it is just parents. The idea is that they want people to know what they want. They want the parents to know what they want. They don't want the parents to be subject to other people kind of asserting these ideas when they may not be the parents' own. So it is just between the parents or just between the relevant parties to try and figure out if something can be figured out. If not, it's totally okay also. Um, but yes, just between the parents. If you did want to talk to your family member, that is something that should be done beforehand in preparation. And there is such a thing as preparing for mediation. So just keep in mind that it's not like you're just going in there without an idea of what you're looking to do or ask for, or how you'd like the arrangements to be set up. You should think about all of that before you go in.
Perfect. Someone's asking, how do they present their evidence to the judge? I'm assuming they're asking, do I just bring it? Are there certain words they might need to say? Just kind of your tips there without getting too specific.
So without getting too specific, just be mindful that so they tell us as an attorney, they tell us, and out in the ether, um, but they tell us to have 4 copies. The 4 copies are for one for me to reference as I'm asking a witness a question, one for the defendant's attorney or the opposing party's attorney, one for the judge to be able to review, and one for the witness. If you're representing yourself, you really only need 3 copies, because the opposing party should have a copy, so that they can see what you're referencing, and the judge should also be able to see a copy if it's something that you want admitted into evidence. There is a process when admitting evidence called laying a foundation. Um, this is going to sound like legalese, and I'm sorry about that, but there's not really a easier way to say it. But when you lay a foundation, you're doing something called, um, or rather, you're essentially providing information about something, um, that it is what it purports to be. So if you are trying to show text communications or something like that, you would need to talk about, here's what this thing is, here's when this screenshot was taken. Um, I haven't altered the screenshot, and it's a fair and accurate depiction or a true and accurate representation of the text at that time. Um, Essentially, you just need to provide sufficient facts so that the judge knows that it is the thing that you're saying it is, and that you haven't messed with it or changed it in any way. But usually that's sufficient. It can become a complicated process, so it really depends on what you're trying to get in. Um, but yeah, tips, simpler the better. There are records that you can also kind of get in, but the main thing is simpler the better, especially when you're not familiar with the process. So things like pictures, screenshots, that sort of thing. Uh, yeah.
Next question. Someone's asking, I think the better part, first part should be, is there such thing as grandparents' rights? And if so, how does one apply for those? I think is the question here.
So there are grandparent visitation rights. I'm not particularly knowledgeable about the process of that, but I imagine like many, like institution of any claim, it's kind of similar to what we've talked about today. Um, in order to initiate that case, you would essentially have to file either the same or similar forms, just noting specifically that the relationship to the child is one of a grandparent to a grandchild, um, and then kind of asserting why that grandparent deserves visitation. I would suggest doing a little bit more research, but there is a claim for grandparent visitation rights with a grandchild.
Perfect. Someone's asking, what were the statutes mentioned in the beginning? If you could clarify what you mean by at the beginning. Uh, I'm assuming this person maybe is asking about the forms. I did put a link in the chat to the NC Corpus website, which also has the information about all the forms, as well as a link to the Legal Aid North Carolina Child Custody Packet, which I believe has some copies of those forms as well. Okay, next question.
Well, and I was going to also just throw out the laws are not particularly easy to read, although I would encourage if someone wants to feel extra prepared, they can look at them. I would advise, well, obviously I'm not going to advise, but I would, if it were me, I would do that. So North Carolina General Statute 50A and 50-13.1 are the two that deal with custody.
Perfect, even better. Someone's asking, it seems like there is a temporary custody order in place. If they were looking to make changes of that, would they be filing, I guess when they say new, I think they mean filing a permanent order, or would they just be modifying that temporary order? Not sure if you can answer that.
Well, so if it is a temporary order, and I'm trying to find the slide. If it's a temporary order, you actually wouldn't file anything. You would essentially, again, this depends on the county that you're in. So I think the best thing to do is to talk to, if you want to modify the order, ask the clerk of court in that county what that process is. For some counties, it is just setting another hearing, which means you'll need to have a notice of hearing um, and a sorry, I cannot think of it off the top of my head. Notice of hearing and calendar request. They're the ones who are going to know the appropriate dates and times for the hearing, as well as maybe an assigned judge. So it's important to ask them when it can be set for hearing, but you would just need a hearing, and then the standard would be based on the best interest of the child. And then, yeah, if it's a permanent one, though, there's a higher burden and you have to show that there's a substantial change in circumstances that affect the child, which is why the order needs to be changed.
Um, I don't know if you can see the questions. I'm gonna copy and send something to you. I don't
Oh,
know if you can answer this question. I also don't understand this question, so give me just a second. I'm gonna send this to you. Okay.
is this the, okay, I see. Um,
While you're reading that, can you go to the last slide that had the contact
yes.
information? For those of you asking questions about wanting to ask an attorney something or hire an attorney or something like that, again, legal aid does not represent typically in child custody matters. Um, and so you probably would need to be looking at reaching out to the North Carolina Law Referral Services through the NCBA. Again, their contact information is there. If someone for some other civil legal issue is looking for assistance from legal aid, our phone number is also on the slide that Trinity has on the screen. Be aware online applications for legal aid are currently closed. So we have extended our phone hours to be, I believe, they are from 8:30 to 4 o'clock, Monday through Friday. So you cannot apply online with legal aid right now. We're making some updates to our system. But if you are looking for assistance for a different civil legal issue, um, you're welcome to reach out to legal aid through those means.
Um,
And if you can't
I'm,
answer that, that's totally fine.
well, I'm not sure I completely understand, but the thing is, so once a decision is made on temporary custody, it can be changed or modified by um, setting another hearing in order to request that the best interests of the child be reconsidered. However, if there is a temporary hearing, there's likely going to be a permanent hearing in the future. And so rather than focusing too much time on trying to change something that has already been done, it could, and again, this is going to depend on your circumstances, so it's your consideration, but it could be a better idea to focus on strengthening your case for um, for the permanent hearing. And another thing that's really important is that when a case is brought forth, essentially. I understand that sometimes there is animosity between the two parties or acrimony. That's not uncommon, but the focus here is the child. Um, if somebody is lying, that goes to their credibility, but it's very important to consider whether or not the lie needs to even be addressed. Because don't forget that essentially these are two separate parties that are both talking about the best interests of the child. And so if one party lies and says something about the other party, it's actually more, well, and again, depends on the case, but the options are you can point out that the other party lied, or you could just assert, you know, that's what they said, but also look at how I'm showing you that what they said is not true. So it's not actually pointing out that they lied. So if they're like, well, they're a bad parent because they give the kid, our kid candy, the other person can be like, actually, that's not correct. I do give candy to our child as a reward, and here's when it happens, and here's how I do it. So it's like the clarification that makes that information not necessarily detrimental. Um, the most important thing is that you're showing to the judge why the best interests of the child are met by your version of the custody schedule or what you are asking the court to order, um, rather than trying to deal with the other party necessarily. The judge is the decision maker, not the other party. All right.
And then last question here. Um, Someone's asking if there's already a parent, if there's a parenting plan in place that addresses custody and visitation. Could they just file that instead of going through the mediation process, or is mediation still required if there's already some sort of plan in place?
So I'm not 100% sure because sometimes people call parenting agreements that then become orders, a parenting plan. But if
Mhm.
you're saying that there is no court involvement, and that y'all essentially came to an agreement and wrote it down that this is what y'all wanted to do, and also if there is not, like if you feel like the other party is being somewhat cooperative, it's good to have that structure in place and reviewed by the court so you can file everything and then you can plan, like if y'all are good and you know everything's kind of working under this custody schedule or this parenting plan, you can file, and then you could also file. Um, there's a process called like a consent order, but basically you can just operate under the parenting plan until you have the temporary custody hearing, and you can just let the judge know, you know, we have a parenting plan in place. We just wanted to have the court involved so that it was, enforceable instead of just kind of us doing what we say we're going to do. Um, the judge is going to likely be more than happy to just kind of get that put into place and put into an order. So that way it's an order of the court. The other way that that would happen is once you file for custody and then you're given a mediation orientation date, you attend that, uh, you have your orientation, and then after that, you're going to be set up with mediation. So then you just go to mediation with the parenting plan and you say, we actually already worked this out outside of court. We're both in agreement, if that's true. And we, kind of just want to submit this to you to see if you have any input as far as like, is there anything that we missed considering? Then the mediator will look it over and may be able to help you to add in those missing pieces. And then they can submit that to the court for consideration as like a temporary custody order. Um, but yeah, it never hurts to work with the other side if they're able to be worked with.
Uh, Last two questions. If someone's modified an order, can they also change the venue at that time, or is that a separate process?
Venue change can occur at the time, like it's likely that there's going to need to be a factual inquiry into why that's happening. Um, but they can do them at the same time. They can decide venue before they decide um, the merits of the case, essentially. So if there's a motion to modify, I imagine that if there is a motion to modify, I imagine that there's also going to be a motion to transfer venue. Likely they could be set for the same day. If the judge decides that venue should be transferred to like a different county in North Carolina, then that likely means that the judge will not hear the case after that. And then the case would need to be transferred to the other venue. There's a lot of considerations in there. I would probably suggest talking to an attorney, even if you don't necessarily need to hire. They may be able to kind of guide you on what you need to do to prepare for something like that.
Perfect. And then last question here. Do letters from witnesses, are those sufficient or do witnesses have to come in person?
So, uh, unfortunately, letters are not, I'm not familiar with a single instance of a letter coming in and having relevance in a case. Um, other than like evidence that somebody contacted someone that, said they didn't want to be contacted. A letter is not going to be good. Um, you should have the person appear. If they're a person that you do not think will appear, then you should also consider whether or not they're going to be a good witness for you. If they're a government worker of any kind, so child protective services, if they are a police officer, if they are anything to do with the government, you're probably going to need a subpoena. Um, you cannot, as a private citizen, send your own subpoenas. You must have the clerk send those, or you can send them, but you're going to need the clerk to sign off on them in order to give them an effect. Um, so be aware of that. Lay people, again, you're going to need the clerk of court to issue a subpoena. And sorry, with government workers, you may need the court. Uh, Usually the clerk can sign off on the subpoena. A lawyer can also sign off on the subpoena. Um, and if it is being sent to a government worker, it's likely that the judge is going to actually need to sign off on the subpoena, so it could take a little bit longer. And if it is not a government worker, so just like what would be termed kind of like lay people, just people who are familiar personally with the parties or the child, um, those subpoenas can be issued by um, the clerk. So you just go to them, you tell them, here's who I want to subpoena. You can also print out the form and have it already filled out. They look it over, just make sure the information is correct, and then sign off on it. Then you would be responsible for serving a subpoena. Um, and I believe they do need to be certified or sent by certified mail. Um, Return receipt requested.
And then I think this is another qualifying question that goes along with that. So even if a statement is notarized, that would not be like a written statement is notarized, that would not be sufficient, correct?
That would not be sufficient. The issue with that, just practically speaking, is you're just having one person stating, essentially making one statement, and you don't know what their basis for making that statement is. And even if they write it in there, um, the other party enjoys the right to be able to essentially cross-examine that witness. So it's not necessarily fair for one party to come in and say, I have this letter, and here I want it in evidence. But now the other party is like, well, I can't do anything to like deal with that. I can't ask the witness questions. I can't determine, what their basis of their knowledge is. I can't, um, determine if they even have a credible memory. So it's just kind of out of fairness. It's likely not going to come in, and I am not familiar with a single instance where a letter has ever been used substantively um, as a beneficial kind of statement to anyone. So if you want somebody to testify for you, you should certainly ask them to be there in person.
Perfect. Well, I am not seeing any other questions, so I'm gonna go ahead and say thank you to all of us. Thank you to all of you for joining us, with a special thank you to Trinity for presenting and for answering all those questions. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. And then after about a week, it will also be available on Legal Aid North Carolina's YouTube page, where you can access it at any time. If you would like to register for one of our other Listen and Learn presentations that Trinity mentioned, such as Civil Divorce, this week we are also starting some Fair Housing Listen and Learns. You can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their day.